And between now and then, I'd really think about your decision not to take advantage of an attorney.
I'm a sovereign citizen, Your Honor. I trust in my own opinion.
Facility. What's your name up there?
Alicia Martini.
And then I don't see Ms. Millar up there. Ms. Moore, are you covering that one from here?
Your Honor, Ms. Martini is pro se.
Give me just a minute, ma'am.
Okay.
So it's on the case ending in 853.
Your Honor, on 6/6 of this year.
Wait, ma'am. Just give me a minute, please, ma'am. Okay. So on the new case, Ms. Moore, 25 DV 1023. She's here on a warrant return on that case. She's held on bail on the other case. This is the arraignment on the protection order case, but it looks like they've already set confirmation and trial dates without her being arraigned. How did that happen?
I have no information, Your Honor. Ms. Martini has declined counsel. She wishes to represent herself.
Okay, so hang on just a minute. No trial dates are set on that. On the protection order case, the trial dates.
About 1 minute into the hearing, confusion started building inside the courtroom as officials clarified that no trial date had been scheduled for the protection order case. The court explained that the only trial dates currently set were connected to separate driving-related charges involving a suspended license and operating a vehicle without the required ignition interlock device. During the exchange, light laughter and reactions could be heard before the judge turned attention toward Alicia Martini and confirmed her identity on the record. The judge then carefully explained that she was facing multiple unrelated cases at the same time, including driving while her license was suspended in the third degree, along with operating a vehicle without the court-ordered ignition interlock system installed. As the judge attempted to outline the charges, Martini interrupted and claimed that her original Dewey case had already been dismissed earlier. The judge quickly responded by asking her to wait and explained that he was only reviewing the charges currently listed before the court and was not discussing past cases or possible defenses. He reminded her that although she may challenge the accusations later, the court was only focused on the official allegations filed against her at that moment. The judge also informed Martini that she faced an additional charge involving the alleged violation of a protection order and noted that she had not yet been formally arraigned on that matter. Court officials then stated that the arraignment process for the protection order accusation would likely happen later during the same hearing session. As the courtroom settled, the judge clarified once again that the no contact order allegation remained only an accusation at this stage, but also pointed out that the offence was being treated as a gross misdemeanor under the law, which added even more seriousness to the case moving forward.
Allegations, that's a gross misdemeanor. That carries with it a maximum of 364 days in jail and a $5,000 fine. So anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at little or no cost. You're presumed to be not guilty of the crime charge. You cannot be found guilty unless the prosecution proves the elements of the crime beyond a reasonable doubt at trial, or unless you enter a plea of guilty. You have the right to remain silent. You're not required to testify against yourself. At the same time, you do have the right to testify on your own behalf if you choose to do so. And finally, if you take this matter to trial and lose or are convicted, you would have the right to appeal your court. Do you understand all those rights?
Yes, Your Honor.
Okay. I want to go back to that first right, and that's the right to an attorney. That's an important, and if you can't afford one, as I said, I can appoint one to represent you. And I'm fully prepared to appoint an attorney to represent you in this case that you're in front of me here right now. And most people, pretty much everyone else, when they get the opportunity to have an attorney appointed to represent them, they jump at that chance. But I'm told that you're not as inclined to take advantage of that offer.
Yeah, I'm a sovereign citizen, Your Honor.
Okay. Sovereign citizens can take advantage of an attorney as well.
It's okay, I'm pro se.
Okay. Have you ever, so ma'am, have you ever represented yourself before?
Yes.
Okay. Have you ever gone through trial, jury trial?
No, I never had to.
Okay. Have you ever been to law school?
Nope, never had to. They got dropped.
And you're not a lawyer?
Nope.
Okay.
I'm a sovereign citizen. My charges got dropped.
Okay, but I'm not sure about these cases, but you
They
understand
were
the
already-
As the hearing continued, the court shifted focus toward bail amounts and upcoming court dates connected to the growing list of charges. Officials confirmed that the newer case already carried a $5,000 warrant bond, while older matters still appeared unclear regarding any updated bail conditions. The judge then addressed Alicia Martini directly and reviewed the schedule for her pending driving-related charges involving a suspended license and operating a vehicle without the required ignition interlock device. Court records showed that a trial confirmation hearing had been scheduled for January 7th, followed by trial dates set for January 12th and January 13th. Attention then turned toward the newer accusation involving an alleged protection order violation which had been filed alongside an assault-related charge connected to fourth-degree allegations. The judge entered a plea of not guilty on Martini's behalf and explained that the case would now move forward toward a future pretrial hearing. Officials also clarified that she was not currently being held on the newer accusation because the hearing mainly involved a warrant return connected to the protection order case. The court confirmed that a $5,000 bond remained active for the newer matter, while the judge prepared to hear recommendations from prosecutors regarding possible release conditions moving forward. Prosecutor Mr. Libby then informed the court that the state had no objection to keeping all previously ordered conditions exactly the same as before. He explained that the $5,000 bail had originally been set back on December 1st for the protection order case, and argued that earlier release conditions imposed during a preliminary hearing in October should remain fully active. Those conditions included requirements that Martini commit no new criminal violations and fully obey the standing no-contact order already issued by the court. After reviewing the arguments, the judge confirmed there would be no changes made to the release conditions connected to the earlier case. The court also reminded Martini that her next major hearing date would take place on January 7th regarding the ignition interlock and suspended license charges. In addition to keeping all earlier restrictions in place, the judge finalized a separate $1,000 bail amount tied to that driving-related case as the hearing moved forward.
I'm going to hear from the state on conditions of release on that, and then I'll hear from, I'll come back to you, ma'am.
Okay.
Mr. Libby?
Your Honor, no objection to leaving the conditions that were previously imposed as is. That's the
I'm not sure.
$5,000 bail that was set on December 1st for this new matter, 1023, as well as the previous conditions that were imposed at the prelim all the way back in October 27th.
Which are no criminal law violations, comply with the no contact order.
Yes, Your Honor. Sorry.
Okay.
Yes.
On the case ending in 10/17, there's going to be no changes in conditions of release. On the case, and then your next court date is January 7th, I think. On the case with the operating motor vehicle without an ignition interlock and the driving with license suspended in the third, that'll no change in those conditions also. There'll be $1,000 bail set in that case. In the new case where we are setting where you're getting arraigned on, which is case ending in 1023. I'm not going to hold you on that case either. All prior conditions remain. We'll set a pretrial. We'll do it earlier than that and back these up on the other one. We'll set a pretrial on Wednesday, December 17th. And that'll be it for today here. And then you can be taken back. Do you understand all that, ma'am? Yes.
Can I please
The courtroom discussion then turned toward claims that one of the earlier cases had supposedly been terminated because of speedy trial rights during the pandemic period. Alicia Martini argued that from 2019 into late 2020, no court dates had been scheduled due to widespread shutdowns and delays connected to COVID restrictions. As she attempted to explain her understanding of the records, the judge paused the conversation and invited prosecutor Mr. Libby to respond with his version of the timeline. Mr. Libby explained that according to court records, a hearing had taken place on June 6th, and he personally remembered being present during those proceedings. He stated that prosecutors had requested a continuance at that hearing, while the defense objected. and the matter was then pushed back for only one additional week with an excluded period entered into the record. Prosecutors also reminded the court that Martini later failed to appear for the scheduled trial date on June 23rd, which resulted in a warrant being issued against her shortly afterward. The judge reviewed the court docket carefully and explained that his reading of the records did not match the interpretation Martini was presenting in court. Martini continued insisting that she had received a case status report sometime around June showing the matter had been terminated entirely. The judge responded by saying the records visible before him showed that she missed a confirmation hearing on June 6th and later failed to appear again for the June 23rd trial date. According to the judge, that missed appearance triggered the warrant and likely caused the cancellation of the scheduled trial proceedings afterward. Martini pushed back again and firmly stated that the paperwork she saw specifically used the word terminated rather than simply canceled or postponed. The judge answered that he could not find any language in the official docket supporting her claim and explained that the records in front of the court did not show the case had been fully dismissed. Martini then asked the court to release her so she could gather the documents and provide proof supporting her argument about the case status and the disputed court records.
Yeah,
Mr.
on
President,
6/6 of this year, there was a case status report from the Thurston County Clerk stating that it was terminated or vacated. Terminated. Case terminated due to speedy trial rights, because if you notice from 2019 to somewhere late in 2020, there was never a court date set because of COVID.
Okay, so hang on just a minute, ma'am. Mr. Libby, you wanted to say something?
So I'm seeing there was a hearing on
6/6,
June
yes.
6/6. I was present for that. I believe the state asked for a motion to continue. Mr. Pazderka objected. The hearings were reset 1 week, and we entered an excluded period.
Right. And then she didn't appear for trial. And a warrant was issued on 6/23.
Yes, I'm seeing that as well. Yes.
So ma'am, I'm not reading the docket the same way that you are.
Okay, maybe
you
the
were
date that
supposed-
I have is wrong, but it said case terminated. I got a case status report sometime in June, I believe.
Okay, and what my reading of the docket says, you were not here for confirmation on June 6th. The trial was going to be set for June 23rd. You were supposed to be there on June 23rd. You did not appear, and then a warrant was issued at that time. And I don't see anything. One thing that may have been canceled was your trial date was canceled once you missed your court date for a
No,
warrant.
it literally
But the
said
case was
case
never met.
terminated.
Please don't, okay. I don't see that. And I don't see that in the docket that I'm looking at.
Your Honor.
And so,
So I'm
If I
asking
may.
to be released so I can get that information for you.
Okay.
go ahead.
Nothing, Your Honor. I'm just trying to clarify stuff.
We'll go ahead if you can. That would be great.
There doesn't, Mr.
If
Chair,
there's
point
ever a
out,
case in need of clarification, this would be it.
there does appear to be a 2017 Superior Court matter that was vacated. I believe it was a Blake case.
I can help Your Honor.
Oh, I see.
Here, case 17, TAC 1, TAC 04338, TAC 0. I wonder if Miss Martini is maybe getting that case mixed up. That was a Blake
No,
vacation.
no, I'm not.
Okay.
That happened.
So ma'am,
It was case terminated, not vacated. Yes, I had a case vacated as well, from the last time I was in prison, but this case was terminated. I'm just asking that I please be PR'd. These are not violent crimes. The victim was not the reporting party of the no contact order violation. I don't have any way to post bail or any way to even contact anybody right now, as the victim was my only person that I had in life, pretty much.
right,
So
ma'am.
I'm just asking that I be please PR'd.
what I'm going to do here for today, ma'am, I'm going to set the protection order. The new protection order will be a pre-trial at on 10 a.m. on December 17th.
The judge then explained that the court would temporarily pause the matter and place it back on the calendar while officials reviewed the confusing details connected to the older driving-related case. He stated that, at that moment, Arlisha Martini was only being held on the charges involving driving with a suspended license and operating a vehicle without the required ignition interlock system. The judge acknowledged that the case had likely been active for a long period of time, but noted that Martini had now officially requested a review of her bail conditions. Because of that request, the court decided to continue the hearing for another 24 hours so both sides could investigate whether the disputed case had truly been dismissed, vacated, or remained fully active. The judge explained that everyone would return the next day for a new bail hearing focused on the suspended license and ignition interlock charges, while any additional matters could be addressed afterward. Just as the discussion seemed ready to move on another issue, suddenly created more confusion inside the courtroom. A question was raised about whether Martini was actually being held on the newer protection order violation charge, since a $5,000 bond had previously been mentioned in court. The judge responded by explaining that a warrant had originally been issued for that amount, and that Martini had already been taken into custody on the warrant, meaning it had now been officially served. He added that after a warrant is served, the court must then decide whether new bail conditions should remain in place or be changed moving forward. Prosecutor Mr. Libby then stepped in and argued that his reading of the court records showed Commissioner Wool had already imposed a $5,000 bail back on December 1st, connected to the newer protection order violation case. After reviewing the docket again, the judge admitted that he now saw the earlier entry and realized he had missed it during the first review of the file. He then confirmed that the discussion was connected to the case ending in 1023, and both sides agreed on the case number before the hearing took another unexpected turn. Martini then spoke up once more and directly asked the court if anyone knew the reason she had never actually been arraigned on that earlier date, which immediately shifted attention back toward possible procedural
I wasn't
issues
arraigned on that
in the
date?
case
I don't have
history.
any other notes, Your Honor, other than
Yeah,
bail was
why would
imposed and
they-
arraignment was just set for today. I don't know why it was set for today.
I don't either. And that was Monday?
Yes.
We'll just put all these on tomorrow. Do all these on tomorrow for conditions of release and set all that. We've taken way too much time on this right now. So ma'am, you could have conditions of release addressed on all these cases tomorrow at 1:30.
Okay.
And between now